The three commissioners are here: Dwayne, Roman, Lori, Tim Reed, me, Ellen. We've got Glenn Kepke, a citizen, and then we've got Casey, the human resources person, and Mary. And I initially was saying that maybe we should close this because it's regarding the lawsuit, but I changed my mind, so I wanted to check to see what you thought. I thought it probably should be open since we're talking about possibly abandoning a road or, but if you feel like it's a litigation strategy.
We're not going to, you are not, first of all, making any decisions today.
Right.
If you ask me questions about strategic information in the lawsuit, I will decline to answer them in a public session. Anything that will, I think will cause you issues in the future.
Right.
Because the minutes are taking, right?
Right.
But I don't have any issues with it not being closed.
Okay.
I'm always, frankly, you're a government, so the more you can let everybody know what's going on, the better.
Right.
Mm-hmm. So. Sounds
good. Okay, so last week we were talking here at the commission, and there were some questions about the situation with the possible abandonment of the road. And Tim, let me know if I'm saying this correctly, but there's some issue. There's a couple questions just about and this does touch on the litigation, but I don't think it's anything that's private. Okay. Now, you had indicated that Ms. Aarestad had filed a third amended complaint.
Correct.
And the court accepted that in the federal court?
Yes.
Okay. So
the court issued a scheduling order and allowed her to. Her representation to the court in August at our hearing was that she was going to amend the complaint to include the weed district because she previously had issues with the enforcement of with the weed contracts and gravel pits.
Mm-hmm.
And her other representation to the court in August is that she was going to amend the complaint to sue DEQ, Department of Environmental Quality, over their enforcement and supervision of gravel pit permits.
Okay.
So then the judge in August set out a new scheduling order that said, okay, here's the date by which you can amend the complaint. When she amended the complaint, she did not include the weed district, and she did not include DEQ. She modified the complaint to have, four counts against Tricon Realty, Inc., and 2 quiet title counts against the county, and we can talk about those a little further. And then she renewed her complaint of the count where she alleged that 2 Rivers Road, the dedication on the plat had been abandoned.
Okay.
At least as to lots 1 and 2. So the quiet title, the purpose of a quiet title is to ensure or clear up the ownership of any parcel of land. 2 Rivers Road is a strip of land that was created with the recording of the plat. It says road tract on the survey, and there's dedication language that dedicates that to the use of the public. Okay? But it's a strip of land. Until the Mineral County surveyor looked at it and did all the calculations, Ms. Aarestad believed that tract of land was indeed it was an easement, and that she actually owned fee in it. And the easement is the right to use somebody's property, and fee is when you own it. So she thought she owned it. Then the Mineral County surveyor did the survey work and determined that that is a strip of land. It's not owned by Ms. Aarestad. It's not owned by the trust that owns Lot 2, and it's not owned by any of the adjacent lots. Everybody bought their lots. They bought lots 19 through 1, and they bought the lots, and they did not accept ownership of the road. I don't know particularly if the road is owned by the Magueras or there was a subsequent transfer to the people who did the subdivision, but what I can tell you is I do know that road strip is not owned by the lot owners.
Okay.
And so she filed this quiet title action trying to, I guess, clarify who owned the road. Mineral County has never owned the road. Mineral County's never had any ownership. There's no record that you've ever owned the road. And literally that means you don't own the fee in the road. That has nothing to do with the right to use admitted on behalf of Mineral County, we don't own the road. So,
Okay.
I mean, so for purposes of the quiet title action, Mineral County's already resolved that issue. She can go ahead and quiet title against the other people if she wants to, but frankly, filing the petition to abandon that portion of the road that bisects lots 2 and 1 is easier for her than finishing a quiet title action.
And that would include all the other landowners if she had to quiet title it.
Well, it would include, and she would include anybody who owns interest in that's just an ownership interest, right? So she has not yet named anybody in the caption or served them on the quiet title to say that Magara's or Magara's descendants, for example, have an interest in the property, in the road strip.
Okay.
And she can, I mean, that's up to her. It doesn't really matter from a standpoint. That doesn't have anything to do with the dedication language that grants the public the right to use it.
Okay. But do you think she
does? Always kind of think of it in layers, right? If I own a piece of land and you drive across it and I tell you to stop and you keep doing it for 5 years, you gain the right to continue to drive across my property, but you don't own it. That's an easement. You just get the right to use my property to drive across.
Right.
That's different than this road strip, because the road strip, who owns it, doesn't have anything to do with that dedication language on the face of the plat that says it's dedicated to public use.
Okay.
You got to always in your mind segregate ownership from use.
Okay.
So before we go any further, anybody else have any questions on those parts?
Tim, how's that sounded? How does that sound? I mean,
I don't think we've done adequate research.
okay.
I think there's a deed from
I can't
Magara
hear
to the county.
Mr. Reed.
He's not sure we did adequate research regarding the ownership of the strip?
Yeah, I think there's a deed from Magara to the county for that strip of land.
There's a deed from Magara to the county for the entrance road that crosses the railroad tracks. There is not a deed for that strip of land.
The legal description isn't that clear on it. It was for that strip of land.
I'm sorry, I can't hear you.
He was saying that he didn't think the language was that clear and that he thinks it is for the strip of land.
Well, I've looked at that deed, and Jane and I have examined it, and I have reached the conclusion that it doesn't include the road tracks created by the Two Rivers subdivision survey.
Anything else about this particular topic? Okay, and we were talking about this action, and then the amended third amended complaint is all filed through federal court. Is there a way? There was a question raised. Is there a way that the county can ask that it be transferred to district court?
There is, but we have to hire somebody who will value what a public road is worth and tell us it's worth less than $75,000. And I mean, I assume that would be an appraiser. I don't know where we would find an appraiser, somebody who would actually just appraise the value of a strip of land that's dedicated to public use. I don't know where we would find that person, qualifications, and then if that appraisal came back at less than $75,000, we could petition the court to move it to district court. But I made the choice early on that, I mean, that finding an appraiser and getting them to appraise it and going through the hearing process to have the federal court accept it would cost Mineral County about $10,000. And so I made the choice strategically not to spend $10,000 of Mineral County's money to get it to district court.
Right, and the $75,000, just to, hopefully I'm phrasing this right, that's a threshold to get into federal court.
You need to have diversity of citizenship, which Ms. Aarestad has alleged because she's lives in California but owns land in Mineral County. And the second part of that is you have to have diversity of citizenship, and then you have to allege that the action is worth $75,000.
But
All
didn't
she
she
has to
prove it?
do is allege that.
Yeah, all you
And
have,
then the burden shifts to the defendant to prove that's an incorrect allegation. So she made the allegation, and I made the choice not to spend your money to fight it.
okay, so she just had to allege that there was diversity, and that she alleges that the value is more than 75,000, which is something that the court said. It's not something we said. The $75,000 threshold is something that the court requires.
That's something that the federal rules require before you can file in federal court.
Right. Okay. I'm trying to think of what. Regarding a Tricon, or now it's Idaho Forest. We were talking a little bit about that, about the road abandonment. Can we talk a little bit about that? Do you think?
Sure, her petition to abandon?
Yes.
We can talk about process, yes.
Yes. And maybe and that's just for our edification, I
What you
think.
need to know is that, I just don't know what the conversations were, but at the hearing we had a few weeks ago, Ms. Aarestad moved to dismiss all of her complaints against Tricon Realty, so they're out. All that's left are the 3 counts against Mineral County, 2 of them being quiet title to establish ownership of the road strip, and 1 of them being her previous count on the whether the language on the face of the plat that dedicated use to the public had been abandoned. So that's all that's left in this case. The last one is already decided by the magistrate and is just pending Judge Christensen's ruling. And let's talk about that process for just a minute, because then we'll move on to the road abandonment. But in federal court, when you have a summary judgment, which we did, the magistrate makes findings and a recommendation. And the magistrate, based on the arguments presented, made findings that no one had specifically abandoned the public's right to use the road tract created and dedicated on the face of the Two Rivers plat. Okay? Then you have 30 days after the magistrate makes the findings and recommendation. Any party has 30 days to object to those findings. Nobody objected to those findings. Nobody objects, then it goes to the chief judge for essentially an adoption of those findings. So we've just been sitting and waiting for Judge Christensen to sign off on the findings. At the hearing we had a couple of weeks ago, Ms. Aarestad indicated she found new law that she wanted to tell Judge Christensen about, but she had not filed her objection to the magistrate's findings and recommendation. So the magistrate told Ms. Aarestad she would have to petition Judge Christensen to allow her to make any additional findings, and then, or make any additional motions. He would have to grant that, then she would be able to proceed. She contacted me last week and asked me if I agreed that she could submit additional information. I did not agree. I said, no, we object. And she hasn't filed anything since then. So I don't know what her plans are, but that's where we sit on that. So in the meantime, and as a separate process, she's filed a petition to abandon that portion of the road tract created by Two Rivers Road, the Two Rivers plat, as it bisects lots 2 and 1. And that petition, I have not seen anything from the clerk and the recorder yet to validate those signatures on that petition, but as far as I know, based on the information I have, I believe that it's the Hammer Revocable Trust and Ms. Aarestad are the owners, and therefore we have a valid petition requesting abandonment of that portion of Two Rivers Road. It's filed under a road law section that allows the county commission to consider abandoning streets in an unincorporated town site. And I've done the legal research backwards to be able to say that the term unincorporated town site can be interpreted under Montana law to be a subdivision plat or a pre-Montana Subdivision and Platting Act plat. So I've done the research to be able to tell you that the commission has the authority to consider the petition as it's been presented.
Okay, and does Idaho Forest have any say in this? Because that section that kind of goes between 1 and 2, does it kind of backs up to Tricon or Idaho Forest?
That section of road no longer touches anything that Idaho, is it Idaho Farm? Is that what we,
Idaho Forest Group.
Sorry.
Idaho Forest Group.
Okay, Idaho Forest Group, okay. Because of the realignment of common boundary that was done between Aarestad and a settlement with Tricon Timber, that portion of the road does not connect at all with the property to the north, which is now Idaho Forest property. So, I mean, they certainly are a member of the public. They could come and comment at the hearing in January if they want. But they don't, they do not have an easement across Lot 1 anymore, so that they don't have access through Lot 1 anymore as of the recording of the realignment of common boundaries.
Is that how you understand it, Tim, do you think?
I don't know.
You're not sure?
It sounds, I don't know.
Okay. Now also, we were talking a little...
Again, I couldn't hear Mr. Reed, so I don't know what he said.
Yeah, he's not sure. I don't know, is there something we should look into, Tim, to just clarify? No? Okay. And I know it was brought up, Ms. Aarestad keeps, filing stuff or wanting to amend things. Is she getting to the point where these are frivolous filings? Or violations of any civil rules, do you think?
No, I mean, I don't, if you're talking the equivalent of a Rule 11,
Yeah,
I'd say no.
okay.
I wish they were.
Mhm.
But when you get to the point of vexatious litigant in Montana, you need a lot more than this to get a ruling that even limits the filings. And they don't. I haven't spent any time researching it in federal court, but if the federal court reached back to Montana law,
Yeah,
we
it's the
wouldn't be
same.
successful.
Okay.
Yeah, I think
let me give you some. I don't know how much you all know about vexatious litigants, but when someone continues to sue over the same things and sue the same parties over the same events or surrounding the same land, the Montana court has adopted. We have a claim that we ask the court to declare somebody to be a vexatious litigant. And when you're a vexatious litigant, you can ask the court for a number of remedies, one of them being is to preclude them from doing any filings on the same topic or against the same group or party of people without having a district court judge approve that. And I come to this with a little bit of knowledge because if you look this up, there's been 3 intervening cases, but the best outline and where the court adopted the Ninth Circuit's criteria for how you get to vexatious litigant. They did it in Mata versus Granite County, and I was the attorney. So, and actually I've got another one, a cross claim right now, out of Choteau County, where the Choteau County has actually cross claimed to have the plaintiff declared a vexatious litigant. So when I've been doing all your answering, I've been looking at that, but while I would love to be able to take care of it for you, we just aren't there factually to make that allegation and have it. I mean, you'd be wasting money, is what I'm telling you. You could make the allegation that would survive rulings, but you're not going to get any kind of outcome that gives you any relief. So, again, discretion being the better part of valor, I prefer not to spend your money to get no outcome.
Okay. And I knew Judge Mata when I worked in Anaconda Deer Lodge County, so I've
read. Lordy, I'm sorry about that.
I've read the case. Yep, I know that case.
Yep.
I guess I didn't realize you were the attorney on it. I know that case.
That was me.
Yep.
I do have a Christmas card where he signed it. He and his significant other signed it. Elena and Vexatious Dick. I'd be happy to send to you.
Yes, that sounds about right.
Yeah.
Okay, and Casey did ask me on Monday, she was going to run the ad, the notification about the petition to abandon, and I asked her to wait until we had this conversation, so it's going to go in a little later, but my suggestion...
So we didn't make the 20th as a publication?
No. We didn't.
Okay, then we have to move the date of the hearing.
Yeah. But I wanted to have this conversation
Okay,
first.
No problem. I just had already told Ms. Aarestad, so she can
Oh.
make flight arrangements.
Oh, okay. Yeah, oh, I'm sorry about that.
So Susan, I got a couple questions.
Sure thing.
Why should we abandon that road? And what about the utilities that are already in place in that
Oh,
road?
that's another question.
I'll answer the second question first because it's easy. The utilities stay in place even as you abandon under the Montana law.
Okay, they stay in place, but what is gonna stop somebody
The
from
utility company has an easement to get to them and use them.
forever and ever?
Yep.
Then,
But they're not going to go anywhere because they can't extend any further to the north. So,
then why do we abandon the road? If
Why
the
would you use
utility
the road?
company can use it, why can't the public use it?
it doesn't go anywhere. It stops in Lot 1. And while it's 60 feet wide on the plat, if you've driven up that road, it is about, I don't know what it'd be in the snow, but I can tell you on a good day, assuming a car is 4 feet wide, that road is about 6 feet wide, and that's the only room for it, based on where the structures are built and how that cliff goes up above the river. So it's dedicated to the public, but all the public could do is drive up and then back down. They don't even have enough area physically to turn around. So it doesn't go anywhere. It doesn't. I'm not a big advocate of abandoning public roads, as you well know. That's why
Well,
we're here.
neither are we.
But for purposes of this, all this petition does is ask you to abandon it as that road is in lots 1 and 2. And so it doesn't have anything to do with 3 down to 19 and the part that you're already maintaining. So they're asking you to essentially tell the public you can't drive up and back down. Because you can't get anywhere from there. You can't get to the river. You can't get to the adjacent properties. You can't go anywhere up that road, so it doesn't serve any public purpose whatsoever. And frankly, it's right on the cliff. I don't like the public having the ability to drive off a cliff. We don't maintain it. Nobody maintains it. The Aarestads and the Hammer Trust maintains it. And so, you've got this problem of somebody could go up and slide off, and it's a big drop. That's an impressive hill to climb. And so, it's got liability, and it doesn't go anywhere, and it doesn't serve any purpose. So, I don't know why you wouldn't abandon it. But that's not my decision to make, and that's
Okay.
not your decision to make today.
Right.
That's your decision to make when you have a hearing in January.
Okay.
And how do you feel about that, Tim?
We don't have time for this. I don't care if I don't. I'm not gonna have any opinions anymore.
Why not? This is important to hear.
Well-
What would be the issue with abandoning it, do you think? I know there's no decisions today,
How
but
do you know what's gonna happen in the future? How do you know somebody's not gonna, Joan
Subdivide?
Aarestad is gonna die, somebody else will own that property, something in the future might happen. I don't, and I disagree with that road being on the cliff and everything else. I've been on it 10 times. I don't know who's
Yeah, I
driven
don't know
it,
what
but
cliff, but
it's not that type of road and everything else like that. And we have marked it at the end of the road so people don't go down there anymore. But I see no rational reason. The commissioners went through this whole process a number of years ago and declined to abandon it then. I just on the principle of it is like, forget it.
okay.
And if we don't have a settlement that says she forever goes away, I'm gonna ask you about a restraining order because I don't want her to come in our office anymore. She just bops in and thinks life is great, and it just sets us all on edge. We don't know if she's trying to set us up or what she's doing. I'm sick and tired of Joan Aarestad, and I don't want to deal with her anymore. And if we haven't got an agreement that this is it, it's over, and she doesn't do anymore, then forget the abandonment.
And is that something, Susan, I mean, that we can, that could be a possible legal negotiation of, this is it, you know, because, do you get a sense, I know we're getting close to wrapping this up after all the different aspects of her lawsuit, but are you getting to, I mean, do you have any sense that that this really is it, or do you feel like she may just, this is something that she's doing as almost like a hobby, or that she's always going to bring something up?
Weeds
I-
or whatever.
I can't hear who was ever speaking.
Oh, I was just joking. Weeds or whatever. I mean, who knows what's next? Maybe.
Well, okay, so there's a couple of things that you have to consider, which is that she has made, as far as I can tell, a valid application under a public process. You certainly, as a government, cannot hold that hostage for an agreement from her, whether you like it or don't like it. So, I mean, there's nothing, I can't go to her and say, well, the county commission will agree to abandon it if you drop your
Promise
lawsuit.
never to, yeah.
Can't do that. Because first of all, she's entitled to utilize the law as it exists. And you can't make a predetermined decision on a public hearing. So, that is not a matter of settlement or negotiation. Do I think that she would agree to it, even if it were possible for you? No, I don't think she would agree to it. But do I think this case is at an end? Yeah, I think this case is at an end. Mineral County doesn't own that strip of the road, and the court has already held that Mineral County and no one abandoned the public dedication. So for purposes of her lawsuit, we're just churning the wheels of justice to get everything done so that we can close down the suit. Separate and apart from that, were the county to abandon it, then she doesn't have any more issue that she could sue the county over with regard to this road.
That area.
So there's some advantage there. If you abandon it, I'm going to file an immediate motion to have it declared, the rest of her lawsuit declared moot, even with the judge not ruling, because then if you abandon it, then her whole claim about it's private is now resolved. So that would end the lawsuit, whether she agrees to it or not. But can I guarantee you she's not going to try and file something else? No, I can't tell you she's not going to try and file something else. I do think that if she tried to file something else, then Mineral County has, at least against Mineral County, we have extraordinarily strong remedies in the federal court to say this matter has been fully litigated and adjudicated, and it's done. So it would get wrapped up quickly without all of this. Now, does that stop Ms. Aarestad from accessing public offices? No. She's entitled, like everybody else as a member of public, to any availability of any public office.
Yeah, and now if she's getting, if she's out of hand, if she's, using vile language or something, then we that could be
I'm
something.
not saying access, I'm saying that there's a procedure when we're involved in litigation. In the past, we've always had the person suing the county go through the county attorney and say, county attorney, I need access to these things. Then that gave us a warning that this person was going to access our office and what it was about, so that we kept everybody in the loop, so that we weren't doing something that, if we would have passed it by the county attorney, they would have said, well, yeah, don't do that. But
Yeah, and I'm not sure about that either, because I think it goes back to public access.
I'm not denying public access. It's just that here's a procedure. If you want something from us, you contact the county attorney, and the county attorney says, this is what she's requesting, and that's what should be made available.
Yeah, but my concern there is just because somebody is suing us, they have a different process of getting the same information that if I, as a citizen, just came into your office and got. I mean, should somebody who is suing us be treated differently in terms of how they get information from a public office? You think? Okay. Yeah, I'm not.
Well, and I can't quite hear Mr. Reed, but I would tell you
My
that
name's
I have
Tim.
the same concern as your county attorney. If you start treating people who are suing you differently, that sets you up for another lawsuit, not in federal court, but in Montana court, in which our Supreme Court is most likely going to take the side of the person who is being treated differently and not take the side of the public office. Because that's where our court is going on these things.
What other questions were we talking about last week, Tim? We talked about the frivolous. We wanted to go over the lots on the, if Tricon or Idaho Timber had any connection to if the road is declared abandoned. We've heard the pros and cons about, oh, yes. Oh, good. I had mentioned to you, Susan, when we talked last week about the cost of publication, and Tim just handed me something. It's, okay, if a person is required by law or ordinance to pay for publication, the payment must be received before the publication may be made. I'm not sure if she's required to, but it's section 7(1)2121.
Right, but there's nothing in the statute that
Requires her to pay.
requires the applicant to pay for the publication
Yeah.
under the road petition. And unless you have some other resolution you pass, she's not required by law to pay for this.
Yeah, I'm just looking at I don't know of a resolution, but yeah, I'm looking at this in the first part where it says if a person is required by law. And I don't think she's required by law. Unless we have an ordinance, which is something we can
So
check.
that's the law they're referring, if required by law, meaning a local statute or ordinance.
Yeah, if we have an ordinance that says, okay, if you're gonna
Okay.
file something against the county or you wanna declare something that requires a public notice, you're gonna have to pay
Okay.
for that.
So we might have to make that a resolution if it doesn't exist here.
Yeah, if a person is required by law or ordinance to pay for publication, the payment must be received before the publication may be made. That's great if we had something that showed that she has to pay for this.
That might
And we don't
require
know of anything.
Research, yeah, we'd have to look, some of those resolutions are still on paper and you have to look them up.
Yeah, so we know, I mean, statutorily, we don't know of anything, but maybe we do have an ordinance that addresses that.
Whatever, yeah.
What else, Tim? Can you think of anything else that we have to hash through?
She will.
Will you please, just so she can hear you? I smell good. I really do.
So we
Merry Christmas.
abandon the road. That's it.
Well, it's-
Leave it at that.
Well, and that's just something that Tim is just saying, so we abandon the road, but that's an issue that is going to go before the commissioners, and they may choose not
Okay, so
to.
they decide to abandon the road. and
Okay.
It's just, they've
Hypothetically.
decided that. and
Yeah.
then We're done at that point.
Right. Well, with this lawsuit now, like Susan was saying, we can't predict that Ms. Aarestad wouldn't then file something else, but in terms of this issue, then Susan would be able to let the court know, hey, wait a minute, this has all been litigated, we're done with this. Could she bring up something else totally unrelated to this? Maybe. But so could anybody. Anybody could file a suit against the county. And then the question is what are the pros and cons that the commissioners have to consider with abandoning just this section? Is it worth it to the county, or down the road, are the commissioners making a decision that could affect something down the
They need
road?
to have that all at the hearing.
Right,
At the same time, when Ms. Aarestad is available and present to hear it and respond.
right, and the public.
And the public.
Yeah.
Exactly.
So nothing's been decided yet. There's no. Yeah. Any other questions, or is there anything else, Susan, you can think of that might help us?
You need to let me know when you're going to have this hearing, because I was.
Yes, I apologize. Yep, I forgot, and I think I did see an email about the date, and Casey did call me on Monday. I said, hang on, because I just wanted to make sure we had this conversation first.
Yeah, so will you get, and while we were talking, I just sent Ms. Aarestad email telling her that we did not publish, so the hearing will not be on the 4th. And I don't know when it is, and we'll let her know.
Okay, and I'll check with Casey right after this, and hopefully we can get it on next week. Get it in the paper next week or the weekend.
If we
you know, I'll
if we
check it out.
published on the 27th and the 3rd, then we could have it the week of on the 11th or the 12th.
Is she responsible for the cost of that publication or not?
Oh,
Did we talk about
you
that?
Yeah.
left the room.
I left the
Yeah,
room.
oh, okay, yeah. Oh, that's why.
You know, that's it, man.
Yeah, we did,
Unless you have an ordinance adopted that requires petitions such as this to pay the cost of publication, the answer's no.
Why is
That
that?
statute says you must be required if there are local laws in place.
Yes,
We gotta check if we have a resolution.
right, and there might be one.
There, we could have one.
Yeah, and the public, publication and content of notice statute, Montana statute says, if a person is required by law or ordinance to pay for publication. So she'd first have to be required before we make her pay for this. And so Montana code annotated
She's requesting
statutorily.
the petition, I mean. only-
Well, and if we
Well,
don't
she's
have a
requesting
law
for the
that, we probably
abandonment.
should make a resolution.
Yeah.
And maybe Tim and Ellen could help us draw one up, because that does seem silly that we get to pay for those $250 ads on
Yeah.
top of all this. You know?
Yeah, so statutorily, no,
Why
but,
don't you have them send the bill to me and I'll turn it in under my end?
Oh. Yeah, well,
yeah, it's part of,
that's
guys
helpful, but
already
yeah,
have
we
your
still want,
deductible.
that's helpful and thanks for that offer, but I was just thinking of having these people have a little bit more skin in the game when they're doing this with us.
Well, and I've got no problem with that, and we can get you an ordinance to pass that requires that,
Okay,
and then you'll have that law in place for the future.
mm-hmm,
Yeah.
But you don't have it at this point.
right,
That's-
right,
that we know
But
of.
I'm
Yeah, we know
serious
of.
about that. I,
Yeah.
I mean,
okay, all right.
It is
this
the
is
cost
in
of-
furtherance of this litigation.
That's
Sure.
true.
And so,
Yeah, I didn't think about that.
you know, I mean, and you've met your deductible, guys, so why not take advantage of those premiums you've been paying?
Yeah, anything else? Anybody have any other questions or concerns? Okay, I'll talk to Casey, we'll get this hopefully published, and again, that was on me. Casey had called me and I said, no, let's just wait.
And me, I talked
So-
to Casey once. there.
Yeah, so that's, and I'm so sorry, I didn't even think about, I don't know why I thought Miss Aarestad, actually, I thought she was gonna be here today, I didn't realize she wasn't in Montana. She's smart not to be in Montana.
And she told me she was actually going to be here, so I'm surprised she's not, but she might be in Missoula.
Okay,
But yeah, I just, plane tickets, I don't know about where you guys are, but for me, plane tickets are extraordinarily expensive at this time of year, so.
yep,
So I said that, so I copied you on the email, Ellen, so when you get that, and you get a date set, you can just hit reply all on that one and let me know.
okay,
And tell her when we've got the date.
you got
It
it.
doesn't matter to me. I mean, it doesn't we just have to publish once a week for 2 weeks with 6 days separation with the notice that says the hearing will be on such and such date. So it doesn't have to be the 11th or 12th. It just needs to be, you just need to be
Meet
able to put
those.
that in the notice.
Right, okay. Yep, you got it.
And Casey should have that notice. So it's
Yep.
one word, so she can.
Yeah, she was all ready to roll on Monday, and,
Okay.
I put a
Well,
kibosh on it,
It's
so.
going to need to be changed now because the dates are wrong in it.
right,
Right?
yep, she'll change the dates. Yep, she's on it, she's giving me the thumbs up.
Yay!
Yeah. So, does anybody else have any other questions while we've got Susan on the phone, or any concerns? Okay. Well, thank you so much, and happy holidays.
Thank you.
Yeah, yeah. Merry Christmas.
Merry
Yes,
to all.
Merry
Thank you.
Christmas,
You
yeah.
no longer have to dream for a white Christmas. We got that.
No, we all have it, and I guess we'll talk to you next year.
Snowing right now.
Yeah, that would be great. And in the meantime, if you have questions, please feel free to shoot me an email.
Okay.
And I know that Mr. Reed needs to do it through Candace, but I will respond to those too.
Okay.
All right.
All right, thank you so much.
Thank you.
Yep.
Thanks.
Okay, all right, bye-bye.
Thank you. Bye-bye.
Okay.
On one hand, it sounds like it's not, the county never had any say in that piece of road, so it's not the county's to abandon. I kind of got that message, but then it came back, the county could abandon it. So, does anybody?
Yeah, well, by a petition, yeah.
Okay.
So I guess there's some state law that says we can abandon streets, and I remember we abandoned one somewhere down there, like where Conley's put that apartment complex.
Oh,
We abandoned a street some time ago down there that hadn't been used for years and years,
Yeah.
but that's the only one I remember, but, yeah, I don't,
Even though the county doesn't own any of
Yeah.
it, we can still say,
Yeah.
well, you can't use that
Yeah.
street anymore.
well, I mean,
abandon
and I
it.
guess the idea there is it's still kind of up to the public.
Yeah.
If a bunch of public came in and said, why would you want to abandon it, you know? It's a public road, and it was.
Well, it must have something to do with that part where she was talking about, if you use the road for 5 to 7 years, then you always have that easement. So maybe by the county officially abandoning it now, it makes it,
You lose that.
Well,
takes away those 5
But
to
what
7 years.
about,
that's what I was
Yeah,
gonna say.
yeah.
Well, does that pertain then to the Sear Iron
Yeah.
Mountain Road?
Yeah.
It's been
that's
used
what
for
she's saying, but
Oh, we should
It is.
ask her
100
that.
years.
it isn't, yeah, but it isn't that, apparently, it isn't.
Well, that would've been a good question to ask.
I know, and
but I mean,
that's always been
That's the
the,
same thing. Is
the rule
that
of thumb is
if
just
you
you-
use something for more than 5 years, then it's established by prescriptive use. So why wouldn't the Sear Iron Mountain Road be
Yeah.
the same thing?
yeah. Yeah, I was gonna ask that too, but then she's on the clock.
Yeah.
Oh. All right, 11:30 in public comment. Looks like we have one interested party here.
Yes, yes, yes. First of all, congratulations on the 410. I'm glad that is a non-issue.
Yeah, me
That's
too.
nice.
Thank you.
Congratulations.
Thank you.
It has to do with the contract, and I wasn't a part of the commissioners and the sheriff's office previous, so I didn't know that this was part of it. I talked to Sean about it, and Sean said, well, we didn't talk about it during negotiations. However, you guys at one point allowed the dog bite as a cert pay and was paying on it. And then the whole thing got switched when it became just union members got the cert pay and Ronnie and Boone didn't get the cert pay. And somehow, I think it was brought up that dog bite wasn't in the contract. So I know that they had wanted that in there,
They,
the sheriff's office,
you mean the deputies?
the deputies, right? Because the
I wonder,
dog.
because there was a deputy here and he didn't bring it up. I totally didn't even remember it. So.
I know, and AJ should have and didn't, and we brought it up afterwards, but I didn't know the circumstances until just like 2 days ago. I didn't know that they were actually paid at one point, then not. And if it's a problem, I know Sean said it goes to past practices, he'll open it up again. Otherwise, I'm happy if you want to just write dog bite in there. If that's something, it's okay. I'm good with it.
You're happy,
Just write
even
it
though you wouldn't be, you mean as a union person, you mean?
Yeah, yeah. We're okay if you want to add dog bite to that. Otherwise, like I said, if you sign it and it's ratified today and that's not in there, I know Sean will open it up as a past practice. So I talked to Sean about that this morning. He sent emails to, I believe, you, Roman,
And I
and
replied
Dan
to
this
him. I
morning.
just told him that after talking to Casey, that after we sign all this and make it legal and valid, then January 5, because today's a payday, so she wouldn't be able to get it done until the
No,
next one.
yeah, we figured January, so I'm
Okay.
good. I think we're all good with that. We all know that's gonna happen that way. So, but yeah, so that was the cert pay question. And then the other issue that I believe the sheriff's office wanted in there, the reason you took a deputy away was because you were taking the jail away from the sheriff's office. Remember how that was discussed? That the jail was going to have the administrator report to the commissioners, not to the undersheriff, not to the sheriff. Do you remember that conversation?
Well, I mean,
Yeah, that's not really a union thing, though. Or is that what-
Well, we were thinking it should be in the contract that that is the chain of command, just as a precaution. And then if it changes, then it changes in the next contract kind of thing. But they wanted that in the contract just to show, otherwise what could end up happening is something gets convoluted and all of a sudden the jail goes to the administrator, who does then have to go because it's not written that it's not under the sheriff's department. So then they do have to go to the undersheriff and or the sheriff. Right now we don't have an undersheriff, but So they thought that, you know, how you talk about in there, how we have the 5 dispatchers and we lost one. We had 6 and we lost one during the strike. We got to keep the 6 detention officers, and you were going to do away with that one deputy position, but we ended up keeping it. And now that we don't have it, I think they just wanted that in the contract, just to state that chain of command, that the detention goes to the jail administrator, goes to the commissioners. Is that a possibility? Otherwise, I think Sean might open it up again for that reason also. I don't know. I don't know that is.
Now it doesn't seem like we're,
I know.
I won't be able to pencil any of that in, that's for
No.
sure.
I was gonna say, you know, if we have 2 issues, then maybe it would be better that it was.
And of course, that'll forestall your retro checks and all that.
Exactly. And if it does, it does.
But, I mean-
I love my deputies, so if we need to do that for them, I'm okay with it.
because
Again, there's only 3 others, so. The deputies would be okay with it. We just have
the
3.
deputies would be okay with what?
With us not getting paid till the end of January instead of the middle of January.
Well, we have it right now, we can
I know.
sign it, and the only thing lacking would be the cert pay that's not penciled in there, and then, and I think that the chain of command thing, it pretty much talks to supervisor, it doesn't say sheriff really, does it? It talks about employee, employer, supervisor.
But we spelled it out
I know that you spelled it
with
out
the
in a meeting.
administrative deal that the administrator will answer to us.
Right, but where is that written down? And if it's written
Well,
down.
yeah, I don't know.
Well,
If it's written down, I would be
I mean, I
happy.
see your point. is
Yeah,
what I'm
I'd be
saying.
happy just to add that written down page to that contract and we'd be done with it. Then we wouldn't have to do that, but I just don't know where that,
Well, I'm just saying, nothing in here says the sheriff, it talks about management, it talks about employee, employer, being the county, it talks about supervisor, it doesn't, you know, the only time it talks about the sheriff is when we're talking about his sworn officers. The sheriff from time to time, at his discretion will determine criteria for deputies' certification, pay, and qualifications to be such. But otherwise, with dispatchers, I don't know if it's necessary, I guess, unless I'm reading quickly, but I don't see anything that really says sheriff is your boss or commissioners are your boss. It says, yeah.
then could I just ask for whatever page that is that you end up putting it down? Or was it a motion on the floor that you actually stated where it was detention to jail administrator to the commissioners? Was that a motion on the floor that you guys
Well,
went
it's
through?
just that the jail administrator
Right.
reports to the commissioners.
But did that have to be a motion on the floor that you voted on? That it went that way, that you took it away from the sheriff's office?
It was a recommendation from the jail committee, and then we took their recommendation in our.
Yeah, in the minutes.
And so I don't know if it
Yeah,
was,
that probably was a motion.
it probably
Well,
was included.
the
All
emotion was,
inclusive.
it was all inclusive in the
recommendations,
recommendations,
So
so.
Casey, can you add those minutes to that contract? Can that be done? Just as, like, there's an addendum A, make it an addendum D?
Well, that would require Fontaine agreeing to have this added and everybody else's. I mean,
Okay. I'm okay if we need to go another week. Can we just? But again, to make it easy, I'd be happy just to have the minutes added to the contract and we're good. Then I think the deputies would be satisfied with that.
So the deputies are worried about,
Well, right now, they're working 40 hours overtime. And if all of a sudden something gets glitched and the administrator now has to go to the undersheriff, who will be overworked as well as our sheriff, before they come to you or in conjunction with you, if that chain of command happens, I know that they're going to be overworked even more.
So if the
I know
deputy-
how much they work.
you said the deputies are working overtime.
Right.
They have nothing to do with it. They're under the sheriff's purview. We didn't change that.
Correct, but if that chain of command goes back to the deputies, goes back to the sheriff's department,
It already is in the sheriff's department. Deputies and sheriff work together and they answer to the sheriff.
no, if the chain of command, the jail administrator
Right.
now has to report to the sheriff.
But why would,
I'm just saying, if some glitch kind of happens this next year, that if that happens, I think we would have to go back to a bargaining table, because you took a deputy away, they're already working overtime. by being one less deputy and now having to deal with the jail and the jail administrator and all the problems that it generates, it does.
So you thought that we took away, you're thinking that we took the deputy away from the sheriff because the sheriff didn't want to oversee the jail, therefore we're gonna, that's what you're making
No,
that?
the deputy was taken away because the pay was given to
The jail
dispatch and detention
Right.
and the jail administrator.
Could-
Under the understanding that the jail administrator reports to the commissioners, not to the
And
sheriff.
that understanding was totally separate from any of the pay thing or anything to do with the deputy. The only reason that was even suggested by the jail committee was, one, that was when we still had Sheriff Bauer.
Right.
Sheriff Bauer seemed to state to them during their meetings, I wasn't part of that he didn't want anything to do with the jail. He would rather be a cop and just focus on the street. And that's kind of what he attributed to why he took it away from Ronnie and gave it to AJ and didn't really have the time or the concern for it. So it was his suggestion. I don't want to mess with it. I just want that guy, whoever runs jail, just to answer the commissioners.
Okay,
So-
so if that's done and in writing somewhere, then I'm good.
It was
Then
in
we
the
don't have
minutes,
to-
but it had
in the
nothing to do with the
minutes.
union contract. All the employees in the union still operate and report to their supervisor. Sheriffs and deputies are not part of the jail,
Correct.
so that did not change. And the jail and the dispatch still report to their supervisor. What their supervisor and who they report to matters not, really. What does it matter whether Ronnie answers to Boone or an undersheriff or to us? What does that matter to the union?
It matters to the deputies because that means all of those duties that the jail could not do, especially when they were understaffed, went to the deputies. They were doing all of the transports. They were doing a multitude of different things that the jailers should be doing.
Maybe only jailers in Missoula County, but in Sanders County, deputies transport. We don't even have a car for the jailers to transport. I mean, the government issued cars are driven by the deputies.
Yeah, we have Ronnie's vehicle. I think
Oh,
that's what they
okay,
were
yeah.
going to use for
But
transports.
I'm
But,
just pointing out that
yeah,
we need to still be a team. We don't need to start
Correct.
being distinct. Well, you took our deputy, so we're not gonna help the jail. Is that
no,
what-
no, they're still gonna help, but they
Sure.
don't want to be any part of that administration part, which gets to be time consuming, is what I'm saying.
But why would they?
Well, because they always were in the past until this new jail administrator happened. So that's what I'm saying. We just need to know that that chain of command is detention to jail administrator to the commissioners, that's all.
But
As long as that's in writing, like you said, in minutes, then we're good. Does that make sense?
no, now you have me worried that people are gonna start being a little bit infantile with working back there now. That's kind of concerning.
Oh, no, I don't think so.
Because
I mean,
whoever
there's,
their bosses are, if Ronnie's gonna call up Boone and go, hey, you know what? I'm short a jailer today and, the cars broke down, I need a deputy to take this guy to Missoula.
Mhm.
Nobody should be bowing their neck to that. This is still Mineral
Correct.
County where we have to work together with our limited resources and funding. And a little bit of language saying, you deputies don't have to answer to Ronnie because she's not your boss, or wherever this is going, that's
No, it was just the fact.
jail. I mean, and what if there's a fight in the jail? Are they gonna go, no, I'm not gonna
Oh,
help
no,
the jailers?
they're- no, they're
That's
still
not
doing-
my boss. I
No,
mean,
they're still doing all of that. It's just that when we were down all those detention officers, we ended up having deputies coming in to do the transport to the doctor, transport to Missoula,
Well-
transport to, and they were doing 2 and 3 transports a day. I mean, Boone was coming out at 6 a.m.
Yeah.
to do transports. And we don't have enough deputies. Right now, we're still 4. So, I mean, that's kind of where their concern was all of that. So,
never mind that some of the jailers quit because some of those deputies were driving them away.
I know,
Yeah, I mean, it's kind of like,
I know.
what do they call it? What goes around comes around?
Well, and that was the other issue too, is we want to make sure that the deputies never, ever get in that chain of command
Yeah, I mean,
again.
if you're gonna poke the bear, expect the bear to get mad. Don't just go, oh, what, now I have to do it?
No, we're wanting to make sure that the other ones are taken away from that as well. It's kind of a double-edged sword. But they had thought, the deputies had thought that that should be language in the contract. I'm just bringing it up.
I haven't heard boo from Fontaine. All he's been asking for is hurry up, cut these guys their check, let's move on.
I'm good with that too.
And And on one hand, I mean, if we were all eager to go ahead and just pencil in the dog bite, I gotta say that I think we do need to have it go back to the contract because,
Okay, I'm good with that too.
I mean, because of this, and that sometimes we have we've been polite, just to be polite, and it doesn't even really get noticed, or it's not even gratitude at any rate, whether it be health insurance paid for an extra month, even though, you know, people are saying this and that about us or whatever. So I've learned that maybe sometimes when we do work with people, we need to kind of get something back in return. And so regarding the dog bite thing, my first reaction would be, yeah, let's pencil it in. But on the other hand, we've been taking advantage in the past. I think we need to put in there, if we're gonna adjust that and add dog bite, we also need to adjust how many can be. We can't have every Tom, Dick, and Harry being paid for search and rescue liaison when only one person goes to the search and rescue meetings. Or we can't have everybody, we need it to be a reasonable number, and sometimes when it's left to the discretion of somebody else. So I think maybe we should get back together and add the dog bite, and then we also should put a numerical number on how many do we need for each of these cert things? Do we need, now I turn the page, so I don't know. Do we need, how many search and rescue liaisons is a normal amount? 2, 1, 3? Not talk about that. How many dog bite people do we need? Maybe 2, maybe 3. But not everybody in the department being a dog bite or being a breath test specialist when only one guy every 31 days is the one that searches the machine. I mean, those are the things we probably need to talk about, and then I think we should probably, I do want to add the dog bite thing, because it's going to be extra work and they're going to earn their cert pay on that. But we need to adjust these numbers.
Just put it in there and then every one of them put in for cert pay
So-
for it, so.
So I guess,
I'm good with that. I don't care if we don't get
I
paid
don't know,
until
I've
the
been
end
doing all the
of
talking and
January.
maybe I
No,
got.
no, I-
That's you,
you're
but
right
then
I know.
are the other ones good with it?
Well, if 3 of the deputies decide they need that cert pay taken care of, I think
Well,
it's
good thing is
not,
we're only 6 months away from the next
I
meeting.
know.
Hopefully nobody's dogs are out biting until June. I don't know.
Oh, I think we had one
They
just
don't
a few
bite
weeks
much.
ago.
Yeah.
Yeah, no, people are visiting for family in the holidays and it happens. So, yeah, as unbelievable as it is, I think, I don't have statistics and numbers, but I know on my calls, some of my dog bites are family members because the grandkids are visiting and those kinds of things. But yeah, dog bites get to be pretty volatile sometimes, because now your dog has to be quarantined for 2 weeks, and it's a hardship sometimes. But anyway,
Well, keep some of these ideas on paper so we can discuss them. And I mean, and like, as you well know, we only had the one meeting and it went quickly because the main focus was, I forgot the dog
Monitoring.
bite thing. I guess Fontaine did too, and so did AJ. He was here.
yeah,
But everything got wrapped up quickly because finally the pay got to be more of a living wage around here. But now we have the document here, and all 3 of us are ready to sign it.
well, and like I said, Sean is okay with you going ahead and signing it and doing what you're doing, and if he needs to bring the cert pay up, if the deputies don't cave, then they can bring it up later. I'm okay with that too.
Yeah. Okay.
But I gotta go to work, I gotta go relieve Ronnie.
All right,
All right. Thanks,
Thank
Ms.
you, guys.
Marie Stewart.
Thank you.
thanks for stopping in.
Yeah.
Merry Christmas.
Merry Christmas too, have a happy New Year.
Yeah,
You too.
I can't believe it's already here.
God, this year went fast.
All right, we're here at 1 o'clock on the agenda. We've got the topic of Commissioner Simons and his work schedule conflict. If anything has changed with that said conflict, and we have some people here today, and as you may have known that he was not going to be able to attend meetings very easily with his, or he thought, but he has an update for us.
Yeah, so since last week, they have decided to go to 410s, and so I'll still be able to attend this meeting.
Good.
So I'm very grateful for that. Yeah.
We don't have to make any decisions.
So
Yeah.
everybody's, the whole mill's going to 410?
Yeah.
Oh, great.
Yeah.
No, I already knew that when I came, but I
Yeah, they're gonna do 410s, or all work 410s, and then they're gonna do one 8-hour shift on Friday of just running big logs, because we always accumulate more big logs than we do little logs, so they're gonna do an
So
8-hour
can
shift.
you
on
give us a
Friday.
quick update on how things are going down there?
Well, I'll tell you what, they're making a lot of changes and a lot of improvements, and we're still working. They told us when we started that production wasn't an issue until they figured they're 8 weeks out yet on where they wanna be to even start worrying about production. So we're getting lots of logs in, we're stockpiling those logs and, starting to high deck logs, and things are looking pretty darn good.
So it looks like it's gonna be a good change?
Yes, I think it is, yeah.
Good.
They brought in a 3-wide modular break room for lunch, and I mean, it's just like a miniature hospital in there. It's fantastic. And, yeah, a lot of meeting room and offices off to the side of it, and a new restroom area. And that was just one of the things, and they've done all kinds of, they had a very, very large list of improvements that they wanted to make to the mill when they started, and they're working their way through that.
We were keeping our fingers crossed it wouldn't happen like it happened at the mill.
Oh,
No.
yeah.
Yeah.
No, I don't, I wondered that myself when they first took it, and I wondered that, but I don't think they're saying they're gonna make 17 to 18 million dollars worth of improvements this year alone. So, I don't think that's gonna be the way it goes down. They own 5 other mills in Idaho, so.
It's Idaho Lumber Products?
Idaho Forest Group,
Forest Group.
yeah.
Where are the other mills, do you know?
There's one down by Lewiston, there's one at Grangeville, one north of Coeur d'Alene, Chilco, one at Moyer Springs. Where did they tell you the other one was at? How many was that?
That was 5.
That was 5, okay. So we'll be the 6th one.
And they're a pretty old company, aren't they?
Yeah.
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 Well, good.
Yeah.
And I heard.
And they were,
I heard Kenny's happy to retire.
yeah, yeah, I think so. Yeah. No, I think they're gonna be a real asset. They're real safety-minded. They've stressed that more than anything.
What, is the pay pretty good down there?
I think it's gonna be better, yeah. Better benefits.
Good, good.
They have a matching 401 that we didn't have before. They just had open enrollment on their medical yesterday, and I didn't attend that meeting, so I don't know what their medical looks like, but I'm sure that it's probably right there too. So yeah, I think it's gonna be really good.
And they
like I said,
employ how many people?
we're still at about the same number.
that's-
I think they didn't bring a few back, when everybody was rehired with them. There was some that didn't come back. I'd say we're still right around 120 somewhere in
That's
there.
good.
Yeah,
Yeah.
yeah. Yeah, so that went really well, and I was very pleased to hear that we were going to 410.
That worked out
Wasn't
perfect.
quite sure how we were gonna work that out.
Good.
Yeah. Well, that's what I know.
Quite a bit of you. Yeah, thanks.
Okay, well, that made it a little bit easier for us then to decide what to do. Anyone else have questions for Mr. Simons and his recent news? Mr. Curtin?
Merry Christmas.
Merry
Thank you.
Christmas.
Merry Christmas to you. That was,
Wait, I got a question for you on that.
okay?
I just thought of it when you said it, I had heard it before, everybody was rehired.
Mhm.
So now, what about seniority?
So what they did there was we started over on seniority, but they kept, if you had, Tricon had a schedule for if you worked so many years, you got this amount of weeks of vacation pay, and they left that in place. So, the seniority didn't come with you, but the vacation did, which I've never heard of that before either.
Yeah,
And,
wow.
That was something very.
If you got
interesting.
matching on the 401k,
Yeah.
that is a big benefit.
Yes, it is.
I know, I had that for many years, and it really helped my retirement.
Yeah.
fund.
Yeah.
It's a big deal.
Yeah, we're very grateful, and they're very, very open. We have a meeting now every morning, at 5:30, and if it takes 20 minutes, it takes 20 minutes. If it takes an hour, it would take an hour. But safety is the issue, and you bring that up first, and then you talk about what you're gonna do that day, and then they go to work, and they were doing those twice a day, but now we're just doing it one time a day. But that is something that isn't going away. It's gonna be a daily meeting. Kind of starts the day out, you know, on a positive attitude.
Sounds like they're pretty hands-on and involved too.
Yeah, they
Yeah.
are. They very much are. No, I think they're gonna be a big asset to Mineral County. And they're kinda anxious to sit down and talk to us at some time.
Oh,
They
good.
said, you know,
Yeah,
we wanna get settled in,
Things going.
and everything's kind of a
Mm-hmm.
madhouse down there now, so to speak, you know, until everything falls into place. But we get things going and get settled in, we'll have to have them down and just, they can have the question and answer time or something if they want to have that.
So they must be the biggest employer in the county,
I would say.
Yeah,
Mm-hmm.
with
Yeah.
the hospital maybe.
yeah, I think it used to go Tricon Hospital and then Lincoln Development Corporation.
Yeah. That's probably still the same.
Mhm.
They threw us a very, very nice Christmas party on Wednesday. Closed the mill down from 11 till 2:30, which is basically when our shift ended anyway. Went over to the community center and everybody sat down and ate dinner. Jerry Stroop catered it. It was a wonderful meal.
Nice.
Wow.
Yeah.
That's a good
yeah.
start.
Yeah, yeah. And they had games and prizes were given away, and yeah, it was really nice.
Do you think they're gonna be pretty community focused
Yes,
as far
I do.
as
I do.
supporting?
Yeah.
Good.
Yeah. And he said, one of their management people told me the other day, he said, that was one thing we want to talk to you about, you know, what are the needs of Mineral County? And
This
we'd
is
like to
great.
hear your needs, and maybe you can hear our needs, and, yeah, so I think it's gonna be really good. Really good.
That's a big relief.
Yeah,
Mhm.
yeah,
Yeah.
yeah,
Yeah, we couldn't have survived another mill closure around here.
no. No, and I think they're setting pretty good with, they assumed all the sales, I guess they did, that Tricon had purchased, and so they're setting pretty good right now. If we can continue that momentum and keep producing some timber out there, and in fact, I think they're working up Tamarack right now,
Mhm.
and I heard Curtis say, well, he doesn't even have to take his chains off, he's just across the street.
So, what about the salvage projects? Like, I haven't been following that too much, but
They're underway.
Good.
Well, yeah, I think it's under, they're done with the, isn't it? They're done with the public comment now, and now they're going through all the comments, and then they'll come out with a decision on what they're gonna do.
We have, Lori and I were at a meeting with Lolo and other foresters and mills, and we talked about some of the salvage sales, not only for here, but the other fires, and we expressed our desire to have maybe a little bit more taken out of their proposal. You know, the 23,000 acres that burned, they barely had 3,000 acres proposed to harvest. So we have another meeting coming on March 15th with the same group at the Lolo Forest.
I know I was talking to Joe Hughes, and I said, I'd sure like, across the creek from our house up higher,
Oh.
there's quite a bit of burn. I said, I'd like to see all those dead trees out of there, and he said, the problem is,
It's in Trout Creek.
drainage.
And they didn't
yeah.
wanna do anything in the Trout Creek drainage because of the bull trout. And they felt that if they did that, they would probably have more objection. And so they wanted to get it through as fast as possible. And so they kinda left the Trout Creek drainage out of it, which is sad.
It is
Yeah.
sad.
You know, I mean, why are we catering to you know.
Well, I know over on McGowan Mountain, they'd probably have to do helicopter logging. I don't know if they do that anymore.
They don't do much of that.
Not much,
Yeah.
you know, there are areas, you know, you go down in California, they helicopter down there,
Yeah.
where the timber's bigger.
Yeah.
There are a few small helicopters that still fly around here, but it has gotten real expensive, and most of the helicopter sales were from years gone by, when there was a big scare that there wasn't gonna be any timber, you know, and helicopter was probably the only way.
Well, and that was the original plan
couldn't.
across the creek from our
Yeah,
house,
yeah.
and nobody bid on it, they
Yeah.
put that road in, but,
Yeah,
yeah.
yeah, but that's kinda went by the wayside for now. I don't know if that'll come back. I mean, it should.
It would be
I don't
nice.
know. There ought to be some way for them, you know, if that timber is there and it's dead, and a catastrophic fire is what, or whatever, beetle kill or whatever has caused it, it's on government property, there ought to be some way that they can subsidize, they subsidize everything else. Why couldn't you subsidize a helicopter to go in there and fly that?
Wouldn't that be
You know?
nice? Yeah.
It isn't none of the salvage timber is a real high dollar turn
That's
on
the problem.
the lumber, because time you get to it, you know, this'll be probably 2 years before, with everything going right, it'll probably be 2 years before they ever turn a log.
Well,
on
no, they're
sunset.
looking at next summer,
Well, but,
but, yeah.
so, look at
here.
it next
I mean,
summer
and
if
that's
they-
the way it was
yeah.
over on the Copper King over on. is-
Otherwise, it's too far
Yeah.
gone, but.
Yeah. So there isn't a real good, it's not the best lumber, but it is lumber. You
Yeah.
know,
Yeah.
and people have grown and gotten used to that. There ought to be some way that they could subsidize the helicopter stuff, I think,
Good thing.
you know? Because there's a lot of areas around here that we've done, I worked for a helicopter company for 14 years, and we did right over here at the mouth of Cedar Creek, you know, and you probably remember that. And you know, you don't even know that that's been done. You know, they do a good job, but it is very expensive.
But the bull trout, they're very important, so they're wanting us to change the name to Bull Trout Creek instead of trout.
Yeah.
My dad used to catch, they used to catch huge ones up there in the canyon when they
Yeah.
first came.
Yeah.
My dad
Huge.
my dad used to throw them out on the ground because he didn't figure they were worth nothing.
We did, as, I remember.
Well, you know, the validity of damaging that creek, you know, that was one of the big battle cries. When they did helicopter Trout Creek when it burnt the first time, you know, they helicoptered that. We were supposed to do another couple million feet in there, and that ended up in court, and they threw it out finally, and we never did get a harvest that. And that was the big deal with them, was the loading of the creek with the sediment.
Yeah.
Well, it happened anyway. I
Yeah.
mean, that stuff erodes off of
Yeah.
there,
Yeah.
whether you logged
burn,
it,
yeah.
whether you didn't. In fact, if you're putting slash on the ground, you're probably better off logging it than
Yeah.
not logging it.
Well, that's it, you
But
get less sediment,
Yeah.
logging, because there's still,
Still got slash on the
yeah,
ground.
you know, you still have bushes and,
Debris.
you know, the root system is still there, burning, I mean, there is nothing to even stop it,
You know, and
so.
you look at, that's been a battle cry for a
Yeah.
long, long time. You look at the hardest log country in the world, in my opinion, and that's the Swan Valley. Plum Creek owns so much land up there, and they've logged that since my dad worked for them. I was that tall. And where's the best bull trout habitat? Swan Lake. You know, it's fact, you know? How do they get around that? But yet, you know, right out of this side of their mouth, oh, you can't do any logging,
Yeah.
you know? Oh, and look over there.
I really didn't know there was any bull trout left in that creek, but
In this
I
creek?
guess they're coming back.
Oh, yeah.
Yeah,
Trout Creek or Cedar Creek?
Trout Creek.
What do you think about Cedar Creek?
I don't know.
Doesn't it dry out most of the time?
Yeah, yeah, right.
They walk up the creek,
They walk up there
Yeah.
I don't
true.
know anymore.
And recently.
on the Bull Trout Amtrak.
Yeah.
Yeah, Trout Creek never gets very low. I mean, it gets low, but it
Yeah.
doesn't do like
Doesn't ever
Cedar
go
Creek.
dry.
Yeah, it's always got quite a bit of water.
Yeah.
Back when my parents, or my family first came in 1929, that was one of the only green places in the county because of the water.
Mhm.
It's still running.
All right, well,
Thank you.
Yeah.
Thanks for your interest in being here.
Yeah, thank you.
Sort of anticlimactic, but sort of climactic.
No, it's a relief.
Yeah,
That's
yeah.
what it is.
It is.
Yeah. Would have been a hard decision. Thank you.
Thank you.
Thank you.